managing risk. So the aim of getting all of your evidence and exposing the risk right is to get a robust final order with consequences for breaches. If you're up against someone who is coercively controlling, obsessive, narcissistic or borderline personality disordered, then they will breach orders. It's important, therefore, that you use those breaches as evidence of their lack of engagement with services, which you've identified as a risk factor, and a disregard of the best interests of the children as determined by the court. Again, another risk factor. Once you have sufficient evidence of the high level of risk they pose, the professional should put in place consequences to deter further breaches and return to court. The overall aim of court for you and the professionals involved is to limit the amount of time children are involved in court proceedings, and a robust and clear final order should focus on that aim. However, there may be some occasions when you feel the need to manage the risk yourself. This might be making a referral to social services, stopping contact, or returning to court. These are key moments in your experience in your recovery. None of them are risk-free and they all have consequences, so we're going to look at them in more detail. So, referrals to social services. I work on many cases where the parent alternates between being neglectful or authoritarian, so controlling and bullying, or not bothered with them at all, which can cause great upset to the child and you because you see the distress your child is in. It can be really tempting to call social services because, rightly so, this is emotional abuse. However, having worked in child protection, I am sorry to say that your concerns are unlikely to meet the thresholds and could in fact cause more harm than good for you and your child. Firstly, you might be accused of making malicious allegations, which can then be twisted to fit the narrative that you're alienating your child from them. Secondly, your child will bear the brunt of telling you, and so they'll learn very quickly from the rage inflicted upon them by the abuser that what happens in that house stays in that house. And this will cause your child to pull away from you and leave them with no one to confide in. And the obvious downside to not referring the allegation to social services is that you could potentially be accused of failure to protect. So it is a double bind. I'm not going to deny that. One thing you could do, after reassuring the child that they're safe and asking them what they would like you to do about it, I have a chapter of this in the book, Help My Child Is Being Used as a Weapon, available on Amazon. Ask them what support we can put in place, or think about what support you could put in place for your child to have someone else to confide in. What this means is that when or if your child makes an allegation to them, that person has a duty to report it, and you get to remain the confidant in your child's life. In my case, the child made an allegation to their teacher, who then asked the parent, who obviously denied what had happened, and viciously turned on the child for making up lies. That child learnt a very important lesson there about her teachers. They couldn't be trusted to protect her. And I appreciate that this is very twisted because, of course, you should be able to do it yourself. But I am mindful of the bigger picture and ensuring yours and your child's relationship remains intact. Stopping contact. And this is a really difficult area for parents who get mixed advice from professionals. Usually those who aren't in the court process will say that it's at the parent's discretion. Those within the court process will, however, see it as a breach. And there is no definitive answer because it does depend upon the situation, but these are some general valid reasons to stop court contact. If a parent or partner is engaged in any kind of criminal activity, any domestic abuse either towards either parent or against others in the presence of the child, where you have evidence of drug or alcohol misuse, and any other inappropriate behaviour that puts your child at risk. I appreciate they're quite broad, so you do have to use your discretion, but really think about the bigger picture and the narrative that your ex is presenting. Obviously, a malicious ex could easily use any of these to stop contact for their own gain. But when you are considering stopping contact, run it through those criteria and ensure that you have sufficient evidence that you can prove that your concerns were legitimate. So the next one is returning to court. Whilst taking your ex back to court because they're breaching or you can't agree on something and they're trying to bully you into doing it their way, might seem like the only way to respond, there are some important steps to take before you go back to court. So the first one is try not to respond to their breaches whatsoever. They are looking for your emotional response. They want to wind you up. They want to make you angry because that, one, feeds into the false narrative, and two, it gets them off. So simply take a note of it with all the evidence to prove it and pop it in the evidence tracker. They want to see that you're irritated or it has caused you some sort of disruption, either emotionally or physically, and that reminds them of the power that they have. So all you need to do is send them, as we've spoken about before, that message saying, as per the court order dated and signed by the judge, you are now so many minutes late and therefore in breach of the said order, or whatever it is, whatever area it is that they're breaching. Do not respond to anything that then comes back your way, any excuses, any slander, anything that they say. Just evidence it, because it doesn't give them your emotions, but it provides you with the evidence. Second point is to collect enough evidence to form a pattern of behaviour. Then, using the legal framework and evidence tracker statistics, apply to the court for an amendment. You want this amendment to cover every eventuality, so prepare a full plan, essentially a straitjacket for them, so they can't wriggle out of it, to limit the amount of loopholes that there are. When you present your evidence, you want to be putting this in the judge's hand by showing them that your ex doesn't respect them. Make it about how your ex is, 1, disregarding the children's best interests as decided by the court, 2, failing to adhere to the judge's, whatever their name is, order, again, puts it back in their hands, and 3, disrespecting the lengthy process you all went through to come up with the final order. You want to be demonstrating that even a court order isn't going to manage this person's behaviour, essentially saying, if they don't respect a court order, how can you expect me to manage their behaviour? And this is where robust consequences are necessary. So the court then has a duty to protect the welfare of the children involved in proceedings. So making sure your evidence shows the impact on children and how, if they don't get it right, the children will be affected. That is so important. Returning to court should be a last resort, but it is sometimes necessary. And the aim of Get Court Ready, this whole course, is to limit the amount of times you have to do this by having the long-term strategy set out at the start.